Everyone, thank you for joining us for today's program, Intellectual Property, Protect Your Firm and Your Compensation. In the short time we have for this program, we will concentrate only on the issue of providing your client with various rights to use your design and the plans and specifications that explain the design in a way that makes it able to be constructed. Many of you provide services other than designs that lead to construction. You might do studies and reports, programming, financial analyses, energy modeling, renderings, right-of-way acquisitions, code reviews, and any number of other professional services. And with each of them, you should be concerned not only about protecting the integrity of your intellectual property, but perhaps more importantly, securing your payment for the services you provide. But we do not have time to look at all the situations, or at your need for confidentiality, or at your role in the integration of design information throughout the process, such as through a building information model. We do not have time to discuss sharing information with a project team or to other consultants or contractors outside the chain of contractual commitments for a project, or for the many other uses and demands for information developed by you. We do have information on our website about using the AIA digital data forms and about the risks to all parties when relying on and sharing digital data. In addition to the comments on the digital data project forms, there's information on a more generic licensing or sharing agreement, an arrangement so you can share documents with contractors and other consultants. This is what we have time to address. We will only be discussing the licensing, transfer, or sale of your intellectual property to your client. Now, I need to give you the disclaimer. As an insurance company, we cannot offer and we are not providing legal advice. You will see some contract language from the AIA and EJCDC and some model language from us. But if you are prudent, you will evaluate it as to how it applies to your situation, and in the case of developing actual contractual provisions, how federal and state laws and case law have an impact on what you want to negotiate. And you'll talk with your legal advisor. So these are general questions I want to answer today. Let's get started with why does it matter? Why you should be concerned about your instruments of service after they are created? Well, you have both business and professional concerns. From a professional perspective, and from a liability and performance of professional services exposure consideration, any reuse of documents, such as for a future modification, alteration, renovation, or as a basis for a different project, may result in meritless claims against the original design professional. That professional liability exposure, however, often can be mitigated by protected language used regardless of the form of the transferred information. We will look later at the standard agreements that grant the owner a license to reproduce the instruments of service solely for the purpose of constructing the building. And we will look at any termination of the contract for design, which automatically terminates the license of the owner to use the information, unless, of course, the termination is for cause, in which case the owner usually has the right to use whatever information had been produced by that time. We really are concerned about keeping the project from being changed by the owners or others. If a termination agreement does not include the design firm's agreement to extend the owner's license to use the documents, the project really cannot go on using the documents prepared by the firm. Usually in a termination, the parties trade the continued use of documents for the payment of all sums due to the design professional and the release of the design professional from any claims. Under the standard agreement, a threat by the client to withhold the remainder of the firm's fee upon a termination, unless the rights to the documents are transferred, is really ineffective. And if you use the AIA B101 2017, you know that there's a fill in the blank for a licensing fee if the owner intends to continue using the architect's instrument of service after a termination. That was put in there to really clarify the process and to keep it from being something where lawsuits go back and forth over use of documents. So a termination fee that gives the owner the right to continue to use the documents is something you negotiate upfront. With other than that kind of an arrangement, upon termination, the firm has no obligation to provide anything, and the client has no right to use the documents, let alone request electronic versions of them. Independent of receiving payment, the firm can negotiate with the client. You can always negotiate with the client for an extension of the license that allows the client to continue to use the project. And you can provide electronic versions if you want. Many firms make the argument if they do not have control of the instruments of service, they are really in violation of state licensure laws, because state licensure laws require them to protect public health and safety. Now, archaic licensure laws can place a bullseye on the design professional, even for things the design professional cannot control. But the situations where a design firm is held responsible for changes made by others are extremely rare. The business concern is much more important. Control over the plans and specifications is about the only leverage a firm has to be able to enforce the payment of its compensation. So the ownerships of the instruments of service should not transfer unless all fees and reimbursables are paid. Ownership of the deliverables and any non-usable preparatory information is the leverage you have to obtain payment. And while every design firm wants to trust its client to fulfill the client's obligations, in many cases, that level of trust seems not to be justified. And that is why the standard instruments grant the owner a license to reproduce the instruments of service once the fees are paid for the professional effort that creates the instruments of service. Now, I am not going to give you a legal course in copyright law, but you should be aware that US copyright law can be helpful. And you also should be aware that because of the US Constitution, there are no such things as state copyright laws. The copyright law in the US changed in 1976. In terms of professional services leading to construction, it was a major change. And since that time, US copyright law has further changed to bring it in line and really into conformance with international intellectual property right treaties, notably the Berne Convention. It created a category of protection for architectural works. An architectural work is the design of a building as embodied in any tangible medium of expression, including the building itself, architectural plans, or drawings. The work includes the overall form, as well as the arrangement and composition of spaces and elements in the design. It does not include individual standard features. It only applies to buildings, however, not bridges or dams or landscapes. One of the interesting examples of how this benefits an architecture firm is what happened with the Rock and Roll Hall of Fame. You might know that's in Cleveland on the lake. And it was designed by the IMP firm, Jacob Fried. After it was built, the Rock and Roll Hall of Fame reproduced the image of the Rock and Roll Hall of Fame from the rendering and put it on mugs and T-shirts and a number of other things that is sold in the store. The IMP firm reminded the Rock and Roll Hall of Fame that it had not licensed that it still owned the right to the image. That meant that the Rock and Roll Hall of Fame actually had to license, it ended up actually buying the use of the image for T-shirts and mugs and everything else. So the firm not only got paid for designing the Rock and Roll Hall of Fame, it got paid for the use of the image of the Rock and Roll Hall of Fame in the store in the Rock and Roll Hall of Fame. Now, if you want to learn more about copyright law, you can download this 8-page publication from our website. The website is www.victorinsurance.us.com/school-of-risk-management. You can download it from the website if you are a policyholder. If you're not a policyholder, we do not always give away our intellectual property. But know these three things that I think are important. Prior to 1976, plans and specifications were automatically transferred to the party that paid for their creation. That was one of the reasons the AIA developed, decades before that, the term instruments of service to denote plans and specifications, not as products of design, but merely as a way to communicate the services of design. That term also helped to keep the product liability laws away from plans and specifications. Copyright is not for ideas, but for expressions of those ideas, and it is an immediate right. You do not have to put a copyright notice on something for it to be protected as a copyrighted original work of authorship. If you do jump through the hoops, put the copyright notice on and actually register the documents, you gain additional rights. But those rights tend not to be that helpful. If you have ever tried to enforce your copyright or looked at those cases, you know that it becomes a long and costly process to enforce a copyright. If you do have it registered, though, it usually means you can collect your legal fees if you finally win. Now, what happens when a client wants rights to the instruments of service? You can provide a license for the client to use that information. And the rights licenses can be expansive and exclusive. You can do the first thing. You can simply transfer the ownership of the instruments of service. But doing so does not automatically transfer the copyright. So the client might not be able to reproduce the instruments of service, create derivative works from them, or otherwise have effective control over them. Or you can transfer the ownership of the instruments of service and the copyrights you have in them. And if it's a building, to the design as an architectural work. We will see standard language in the AIA and EJCDC documents that addresses all these situations. Now, all the standard provisions address 4 issues. But as I will constantly remind you, don't give away any rights to your instruments of professional service. They are manifestations of your service, and as such, they are physical representations of your intellectual property. Architects, engineers, others do not sell plans and specifications. They sell their services. There is one other objective that you might want in addition to these 4, depending on the circumstances, in large part on how you think the client is going to use the instruments of service. You might want to remove any identification of your firm from the transferred information. This, of course, is less important if you're simply providing a license to use the instruments of service for specific purposes, because you have more control in that situation. But if you think the client is, for instance, a devious developer who's going to use the information for other projects, or is going to further lend them to another entity who will use them on another project, you do not want to be dragged into any future problems because some plaintiff attorney saw your name on something discovered during a legal process. Such claims do happen. They are usually easily defensible, but with any defense, they can be expensive, both in terms of cost and damage to your reputation. Now, let's look at what a developer might demand in the contract for your services. A typical developer provision. And this is it. I highlighted part of it. Parts of it are that transfer takes place not when you get paid, but as soon as documents are created, and that they remain the property of the owner. It also talks about referring to them as works for hire. Now, prior to the 1976 copyright law revision, plans and specifications were considered works made for hire, which meant that all rights were immediately conveyed to the party paying for their creation. That is one of the reasons the AI developed the instruments of service, right? To that term. Defining instruments of service, again, help them escape the product idea that might make them subject to the Uniform Commercial Code and warranties of merchantability and fitness for purpose. But what you should know is lawyers, most of whom are lazy and get paid by the amount of verbiage they produce, do not understand copyright law, and they often will borrow a works made for hire provision they have seen and plug it into the developer's contract. Now, the US Copyright Act defines a work made for hire as either a work prepared by an employee within the scope of his or her employment. This PowerPoint is a work made for hire, or a work specifically ordered or commissioned for use. But in that case, it has to fit into 9 enumerated categories, and only if the parties expressly agree on the written instrument signed by them that the work shall be considered a work made for hire. So this language from a developer is an agreement, but what you do does not fit into any of those specially ordered or commissioned for use categories, which are things like a contribution to a collective work, a part of a motion picture or audiovisual work, a translation, a compilation, an instructional text, a supplementary work, a test, or answer material for a test, or something in an atlas, right? So because you do not, what you do does not fit in any of those categories, they're not works made for hire. But look at these, other highlighted provisions. The transfer takes place immediately. That means there's no need to pay for the creator for them. And we'll look at more of this problematic but common provision. So lawyers cover their lack of knowledge of the law and avoid malpractice claims by adding language such as this. In other words, whatever you do is the client's as soon as you do it, right? And that meant you've given away all your rights. Now, I also highlighted moral rights. Moral rights refer to personal rights of creative artists to control the display and alteration of their work and the use of their names. Artists have a continuing relationship with their works, even if they do not own the actual physical work or the copyright to the works. Now, you may be an artist designing something else, but design of buildings or design of engineering works do not create moral rights. Moral rights of creators of copyrighted works generally are recognized in civil law jurisdiction, and to a less extent in some common law jurisdictions. The moral right include the right of attribution, the right to have the work published anonymously or pseudonymously, and the right to the integrity of the work. Preserving the integrity of the work allows the author, the creator, the artist, to object to alteration, distortion, or mutilation of the work that the artist considers prejudicial to the honor or reputation. And anything else that may detract from the artist's relationship with the work, even after it leaves the artist's possession or ownership, may bring these moral rights into play. They're distinct from any economic rights tied to copyright. Even if an artist has assigned his or her copyright to a work to a third party, he or she still maintains a moral right to the work. But in most cases, again, nothing you do will qualify under moral rights. So what's wrong with this provision? You gave away any leverage. The owner does not have to pay you for your services because everything you have documented is the owner's. This, by the way, is part of a developer's trifecta, sometimes referred to as the Trump Organization's playbook. You take ownership of everything immediately. You include a provision that says the developer has a right to withhold any payment at the developer's discretion. And if there is a dispute that the parties, between the parties to the contract, the losing party has to pay the winning party's legal fees. You sign a contract like that, and the only hope you have of getting paid for what you do is based on the ethics of the developer. Usually not a strong way to get paid. Okay, let's look at what the AIA and the Engineers Joint Contract Documents Committee have developed over the decades to deal with the instruments of service. And I've given these to you in a handout. We're not going to go over them in detail, but because you really need to have this language because it really addresses those issues we talked about. This is the standard B101 section 7.3. And it talks about a non-exclusive license. Some owners don't like the non-exclusive language because they do not want the architect to be able to license a design to others. But this addresses the common risk issues, prompt payment of sums, limited use of the information, for construction of the project, and talks about if for some reason the architect has a right to terminate the agreement and does so, the license is terminated. And if the project owner who has a license uses it for alterations or additions, and the architect does not pay to perform additional services for the owner, there's a waiver of claims and an indemnification obligation kicks in. Note that if the architect is terminated for cause, the license remains, but the obligations on the project owner do not. Now, the standard EJCDC language is more specific, but includes the same details. Engineer owns all the copyrights and the right to reuse documents at its own discretion. Provides a limited license to the owner, and they're specific as to the use of that limited license. The owner acknowledges that they're not suitable for use on a project unless completed by the engineer or reuse if the engineer is involved, and otherwise it's at the risk of the owner. Now, it says without liability to the engineer. That often doesn't actually protect the engineer as much. But this does. The owner will indemnify and hold harmless the engineer for such claims. And the engineers are very careful about not letting it be used by other parties as well. Now, both EJCDC and the AIA have alternatives to what's in the standard contracts, and you should know about those. EJCDC creates a category called previously or independently created works, and it includes it in this alternative. And the previously or independently created works can be information developed by the engineer previous to that agreement, but that too can be used by the client under certain restrictions. Again, full payment has to be made first. Now, note that in 7 here, it says there will be any reuse that's not for that specific purpose intended will be at the owner's sole risk. And again, it says without a liability to the or legal exposure to the engineer. That's more guidance than it is law. Again, they added an indemnification provision, which then the engineer can enforce whenever there's any cost to the engineer out of such reuse, right? And again, the engineer's right to create works is not limited. It can reuse the information it provided. The AIA B103 2017 has some other model language that can be useful. If you don't have it, download the current edition of the B503. It's one of the few free things you can get from the AIA, and it's available on the contract documents website, which is www.aiacontracts.org. Okay? Not the main AIA website, you'll never find it. But the B503 has this option for transferring ownership. Again, payment has to be made. Nothing prevents the architect from reusing the information, but the drawings and specifications and data become the property of the owner. It limits what the owner can do with them. It keeps the architect out of the line of fire if the owner reuses the information without the architect's involvement. And it requires the owner to indemnify and hold harmless the architect from any damage that comes the architect's way because of the reuse. Those are important provisions to always consider whenever you're transferring documents. It also has a disclaimer of any warranties. Again, there's always a fear that the law, legal cases will look at any transfer of documents, specifications, or even electronic data as a product. And products have to meet a warranty of merchantability and a warranty of fitness for a particular purpose. And you don't want that applied to anything you do, right? Either your services or the documents created by your services. The B503 also cautions that you have to work with your sub-consultants to make sure that their information can be passed on. Now, this is some general advice we've been providing for at least 30 years now. And again, saying that they are not products. Transfer only takes place on full payment. You're not deprived of the right to retain copies and the right to reuse the information in your normal course of practice. The client recognizes that they can't simply reuse the documents without an evaluation of them in relation to applicable codes and standards, and that if not done by the original design professional, by a legally competent agent, someone licensed in that jurisdiction, providing that information for the owner. And again, we get the waiver language in there, and we get a defense and indemnification provision in there. So again, this is a model that you can discuss with your attorney if you're in a situation where you have to, where the owner really wants ownership of the documents. It addresses those 4 issues that we brought up earlier. It protects you from meritless claims against you and indemnifies you if for some reason one of those claims happens. Now, one of the things we want you to be aware of is that you might be put into a situation where a client gives you plans or other deliverables from another named or unnamed design firm. And you should be careful if that occurs. So what happens when a prospective client gives you a set of calculations or schematic designs or actual plans and specifications and tells you they were prepared by another firm, but they are owned by the client who wants you to use them to complete the design or revise the design or as a basis of an addition to the design. Well, this doesn't have anything to do with professional liability exposure, but it can present a really significant business risk outside of, in addition to any state registration law requirements or responsible charge for the design. So unless the rights to use that information were properly negotiated by the client, you might be violating the intellectual property rights of the firm that developed the information the owner is providing you. And that original design firm has every right to pursue a legal remedy against your firm, to say nothing of going after you on ethics and state licensure requirements. So be cautious, okay? Now, just some final thoughts. One, get paid for what you do, right? And documents, retaining the rights to documents is one way to try to secure your payment. Meet the client's needs through a license whenever possible, because there's more control if you simply give the owner a license to use plans and specifications. Make sure there is an understanding that the client does not have control over your standard details. And we haven't seen cases where firms have transferred their standard details when they transfer the use, a license to, or even the ownership of their documents. At least get a provision that states that any other use other than the intended is at the client's risk. But whenever possible, get language that states that the client will waive any future claim, and try to get the client to protect you from actions by third parties, that indemnification. And you saw it in the standard provisions, you saw it in the one that we recommended. And you know, and really that's why we included the well thought out standard provisions that you would have as a reference. Now, with that, we're going to